माननीय सभासदों, माननीय उपसभापति जी,
माननीय सदस्यगण, यह बहस हम सब मिलकर 5:30 तक कंक्लूड कर लें, क्योंकि उसके बाद वोटिंग होगी। मैं डॉक्टर अभिषेक मनु सिंघवी जी को चाहूंगा वो बोले। डॉक्टर अभिषेक मनु सिंघवी।
सर, मैं वेरी sir, there is a point.
Very unfortunate. I'm quoting rule number 110. 110. So if you look at it, just examine the records of the submissions made by some of our friends from BJP. So 110 very clearly specifies that the argument shall be confined to either in support or in opposition. But where we have seen denigratory remarks about political parties, about political leaders, I think you should examine it, sir, and expunge it.
We'll examine.
In many members or most of the members may not have registered, but honorable members from the treasury benches, those who spoke and deliberately not taking name, they were disparaging and unwanted, unacceptable references made to political parties and national leaders of yesteryears, including former prime ministers. That must be removed from the record.
माननीय आनंद जी,
because the rules are very clear.
House के rules
the rule is very clear.
Examine हो.
Anything outside the scope.
Examine हो. House के rules sir. Dr. Abhishek Manu Singhvi. Dr. Abhishek, please. Dr. Abhishek.
Sir, I rise to oppose this.
Please. Dr. Abhishek Manu.
Sir, I rise to oppose this amendment. There used to be a spoof show on English television, not the 9 o'clock news, to make fun of the 9 o'clock news. This RTI has become the NRTI, not the Right to Information Act with this amendment. It has actually trying to control by a control freak government this enactment through seemingly very simple changes. And let me tell you in a nutshell why it is more sinister, more dangerous, more over clever, because it seems such a short amendment on only 2 issues. Sir, the amendment is very pointed and short. Number 1, it seeks to say that the term of office of the central commissioners and the state commissioners shall be changed from that specified in the Act, 65 years for example, to as may be prescribed. So the change is as may be prescribed by the central government for both central and for state commissioners. The other second change is that the salaries, allowances and terms of conditions, which earlier were equal to the election commissioners, shall also be as prescribed. So these sound two, the entire amendment is basically 2 things. Now why is it pernicious, sir? So firstly, I can understand an amendment moved to strengthen the institutions under the RTI. I can understand an amendment moved by a bona fide government to elevate the institutions. Remember when we brought Lokpal, and I had the privilege of chairing the Parliamentary Standing Committee then, although it was not required, we added a constitutional proposed amendment also to Lokpal, on the ground that it will be largely statutory, but the status will be constitutional. Here, you have a very interesting reverse amendment to devalue and degrade on a very, very strange ground, the strangest ground I've ever seen in a statement of objects. The statement of objects, para 3 says, the reason why we are moving this amendment is the salaries and allowances and other terms and conditions of service of the Chief Election Commissioner and the Election Commissioner are equal to a judge of the Supreme Court. And therefore, unless we pass this amendment, the Chief Information Commissioner becomes equivalent to a judge of the Supreme Court. So the object of this amendment is that a Chief Information Commissioner should not claim equivalence with a Supreme Court judge, and therefore the amendment is brought. Now, sir, I want to ask this august House, has the CAG, has the Election Commission, has the Supreme Court collectively or a Supreme Court Chief Justice complained that you have got somebody else equal to us? Are they feeling insulted that a statute which existed all this while, which gave terms of service equivalent to election commissioners, is so insulting, because election commissioners' terms of service are in turn equated to Supreme Court judges. What a strange statement of object, that we want to change it because commissioners will in this manner be treated as equal to Supreme Court judges. Sir, ultimately you are treated on the basis of the power you exercise. We all understand the powers of the Supreme Court, we all understand the powers of the CAG, the EC. Why tinker with this? And I'll come to the reason, which is much more sinister and surreptitious. Sir, instead of, there are two things in the Act. It says 65. 65 is certainty of tenure. Before I become a commissioner, I know that I will last till 65. Before you accept a post, you know there is 65. That 65 is embedded in a statute, in a legislative document. Now you want to say, by executive order, as may be prescribed. So tomorrow, for 2 years, this government will prescribe 63. 2 years later, it will change its mind and prescribe 65 without any legislative mandate required. It is getting a carte blanche from the legislature, us, that allow us to prescribe what year we like, what when we like. Sir, what is the reason behind these provisions? These are for independence and autonomy of the institution. There are three things. One is age of demitting office. One is terms and conditions of service. Third is salaries and allowances. Now, although you cannot reduce these terms during the term of a person, if you leave it to the whim and caprice of a government, which every 2 years changes the age, changes the terms and services, then you are keeping a Damocles sword hanging as an instrument of power, as a tool of control over an institution which was supposed to be independent. This cuts at the very root of independence. In the United States, they made US judges of the Supreme Court for life. Federal judges are appointed for life, even if they are very old, even if they are critically ill. Unless they decide to resign, they can't be removed. Why? The idea was to give them independence and autonomy. It's very interesting. We have Constituent Assembly debates, which perhaps this government never saw before they got this. The Assembly debate says that a vital condition precedent for independence of the institution, for autonomy, is a fixity of tenure. And that is fixity as specified in a legislative instrument, not as prescribed by executive orders, which the government of the day, according to its mood, can change every 2 years. I want to read, there are many portions, but just read in 1949, May 24th, Mr. Ambedkar said this. This was, of course, about Supreme Court judges, but the same principle applies. And he raised, interestingly, the very same point. Have the age in the statute or the constitution versus as may be prescribed, which is what the government is doing now. And he said, I quote, there are some who say that the constitution should not fix any age limit whatsoever. Exactly what the government is doing today. Says the statute should not fix any age limit whatsoever. But that the age limit should be left to be fixed by Parliament by law. This was between constitution and Parliament. We are one level lower. This government is at the statute level making it executive. He objected even to that. He said, it seems to me it is not a proposition which can be accepted, because if the matter of age was left to Parliament to determine from time to time, no person can be found to accept a place on the bench, because an incumbent, before he accepts a place on the bench, would like to know for how many years in the natural course of things he could hold that office. And therefore, a provision with regard to age, I am quite satisfied, cannot be determined by Parliament from time to time, but must be fixed in the Constitution itself. Now, these poor people are statutory creatures. You now want to fix their age by executive order. Today, the amendment is, take away from the statute, give me the right by executive order. I am saving the time of this august house by not reading Mr. Ambedkar's other portions, which are all relevant. Dr. Ambedkar, Mr. Shibban Lal Saxena, who supported his sentiment, and then Mr. K.T. Shah. In fact, Mr. K.T. Shah made the proposal that such statutes and such provisions should appoint for life without any tenure at all. But we don't have that. We don't have in the Constitution for election, for information commissioners. You put it in the statute, now you want to amend it, take it away, as may be prescribed by the central government. That's why it's pernicious. So one more thing. example of Chit bhi meri, Pat bhi meri. A few weeks ago, it's quite astonishing, the law officer, I believe the Solicitor General of this government, on a judgment by the Supreme Court on 15th of February 2019, that is about 4-5 months ago. This was under this RTI Act called Anjali Bharadwaj versus Government of India. In that, the Supreme Court noted the contention of the law officer of the Government of India. So he tried to save that matter by saying that don't worry, we have section 13, which fixes the tenure in the statute. That was the argument before the Supreme Court. Learned counsel for the petitioners made a grievance that there was no specific condition of service stipulated in the advertisement while inviting application for the post of Information Commissioners. Solicitor General, however, submitted that insofar as salary and allowances as well as terms and conditions of appointment are concerned, that is statutorily provided in section 13. So he was defending, saying, don't worry, the Act doesn't have to say it, the statute says it. And then the Supreme Court quoted the whole of the provision of section 13, today precisely what the Honorable Minister is trying to amend. And after that, the court held, in view of this provision, which you today want to delete, 4 months ago you were defending it and using it to defend before the Supreme Court. In view of the aforesaid provision, it is clear that any candidate who aspires to become Chief Information Commissioner knows as to what would be the salary and allowances and what would be the other terms and conditions of service. At the same time, it is always advisable to make express stipulation of terms and conditions in the public notice. And then they said further, this is vital for transparency. All states should also follow it. Sir, this is playing ducks and drake. You win the case by propounding section 13. 4 months later, you come to this house to say, do away with 13. On a remarkable, specious, spurious reason that as long as 13 exists, election commissioners will claim equality and parity with Supreme Court judges. Sir, Supreme Court is not complaining, CAG is not complaining, nobody is complaining. Only the Government of India is scared of giving some independence to RTI. Sir, if you do this, you are actually going to make it nothing but a Sarkari department. You are going to downgrade it. You are going to ultimately try and control it, because we all know how you control. You want to make sure that commissioners are in your good books so that the prescription of age and service is in your control. This is extremely pernicious because perhaps, I don't know the real reason, perhaps the reason is that there were some bold commissioners. There were some people who gave orders which were bold. There was a case, for example, about age issues. In the age issues, that judgment by a commissioner called Sridhar Acharyalu, he said disclose. It involved and related to the age of the highest executive of this country, the Honorable Prime Minister. Shortly thereafter, the HRD segment of Mr. Acharyalu's jurisdiction was taken away from him. This is the disclosure which came about the age. There are other disclosures about degrees. Now, is that the reason why the government wants to control such institutions? We don't know, but I have a fair guess that that is how you want to control. There is also, sir, the other reason. You want to cripple the institution, and I'll end in 2 minutes on this. You have already crippled it, you want to cripple it more. The crippling is, just see some figures, sir. You don't appoint people for months to the various central commissions and the state commissions, information commissioners and the chief commissioner. You don't appoint for months. 30,600 odd cases pending in the central commission alone. A 2018 report by a famous NGO said that several information commissions at the state level were non-functional because of non-appointment, delayed appointment. They have the numbers here: Kerala, Maharashtra, Nagaland. Now here it is very interesting. The state commission, and that's my last point, sir, is constituted by the state government, no doubt. And there is a complete mismatch. There is possibly a federalism issue here also. The state commission is appointed by the state government. But in the state government appointing it, there was a fixed tenure which is fixed in the Central Act. So a state government will appoint the commission, the tenure will be fixed, given in the Act till 65. Now, the appointment will be by state government. But the amendment today says the age limit will be as prescribed by the central government. Sir, I am the state I am appointing, and the age limit of the person I am appointing is as prescribed by the central government. And that prescription by the central government can change every 2 years. You find a Kerala commission is a little overactive. So let's change it from 4 years to 2 years. Let's change it from 65 to 63. This is pernicious also because it's a complete mismatch. The creation of the commission is by the state, but the terms and conditions, the salaries and allowances and the age is by you. Sir, may I end by saying you need to, at the minimum, refer it to a select committee. These are serious issues. These are national interest issues. And ultimately, we have called it the disinfectant of sunlight, this act. And the biggest ghaplas, if I may say so, are also happening at the state level. So don't treat those state commissions as to be forgotten. You should keep it strong and you should strengthen it, elevate it to a constitutional status. Here you are elevating it to the level of a Sarkari department. Thank you.
Thank you. Sri Derek O'Brien.